Valley Mole.
Hi, I'm David Smith and this is Valley Mole, the show that digs in and around Silicon Valley, searching for insights into technology news stories, the patent wars, and the business of startups. The damages claimed by Oracle against Google have now been reduced from more than $6 billion to about $1 billion, and actually the patent component of that, the patent infringement claim, is down at about $200 million. So why did this happen and what's happening? Basically, the judge asked Oracle to provide their claims for damages, and the Oracle expert presented a claim that did not impress the judge. It was extremely high. More than $6 billion in damages were assessed by the expert, and the judge asked them to revise, and the new figures have come out and look much more reasonable. So how are the damages calculated in patent infringement suits? Well, the basic rule is that the damages must be adequate to compensate the patent holder for the infringement. And there's not a great deal of guideline provided in the rules, but no less than a reasonable royalty is considered adequate. So the reasonable royalty is really a floor to what is considered adequate compensation. The court then adds interests and costs to that. Now, how this is implemented in the case is like the Google Oracle case, is there's a battle of the experts. This is a job for economists and people who are very, very good with numbers. They basically, one of the things they do is look at comparable licenses. What would be a reasonable royalty in this industry? If there were another company like Google producing another product like the Android, and they were licensing patents from another company like Oracle, if that's happened, what were the license rates agreed? That would be used as a comparable to assess what a reasonable royalty may be. Obviously, those things are sometimes very hard to find, and there are specialist firms that gather that type of information and monitor the license arrangements out there in order to provide patent holders with reasonable royalty rates for different sectors. But another way of calculating the damages is to look at the lost profits. So Oracle may want to look at what profits it would have lost by the infringement here in the case of Google. So lost profits are sometimes used. Oracle cannot look at the profits made by Google. That's not allowed. Basically, you can assess damages on lost profits, but not disgorge profits that were made by the infringer. So there's another type of damage calculation which increases the damages threefold. Essentially, beyond compensating for infringement, the courts want to deter infringers from willfully, knowingly infringing patents. So if the court finds that the infringer was willful in the infringement, they were on knowledge of the patents and proceeded anyway to infringe them, then the court can award, and usually will award, triple damages. So they assess what the reasonable royalty, what the regular damages might be, and then they multiply by 3. So this means knowledge of a patent to a product manufacturing company can be quite costly, and that's why you see many companies very careful about receiving patent information and being on notice of patents. And of course, the courts, to prevent future infringement, can award an injunction blocking the sale of the product in future. We covered that in a previous Valley Mole. If you look for the Valley Mole on the Samsung Apple case and the Samsung Galaxy tab, you'll see how we address the issue of injunctions as remedies for patent infringement. So, Oracle's been forced to present more reasonable numbers. This topic, I think, is important to patent holders and to product manufacturing companies, because it's the patent damages that are really driving the litigation, driving the patent wars, and ultimately drive the value of patents. We'd like to thank the sponsors of ValleyMole. Tynex, the full-service patent broker operating the world's largest technology trading exchange. Silicon Valley Business School, the unique online resource for students and teachers of entrepreneurship, high-tech law, and technology commercialization. And ValueMyPatent.com, the only place to go for rapid, realistic online patent appraisals.